Koya in the next hour. Now let's move on to other stories also making headline today. What is likely to impact on the pending Supreme Court judgment of the court on the Building Bridges initiative on the ongoing realignments ahead of the August 9th polls? Well, this is the elephant in the room for top political players and coalition strategists as the 7-judge bench prepares to deliver the verdict, expected to have far-reaching implications on the President Uhuru Kenyatta succession race.
Tonight, our senior political affairs reporter Murimi Mwangi looks at the two likely scenarios in the BBI verdict and explains why key political players can no longer sit easy ahead of the judgment.
When President Uhuru Kenyatta and former Prime Minister Raila Odinga appended their signatures in support of the Building Bridges initiative, there was no doubt the duo were picking a strategic seat as co-drivers of the constitutional amendment push, deemed politically decisive to the August 9th race to State House.
Nobody can stop reggae.
But having since then suffered serious setback in nullification of the BBI process at the High Court and in the hands of the appellate judges that upheld the verdict, the duo have been bullish but somewhat uncertain how to replay the BBI reggae tune.
BBI is just a dream deferred. One day, someday, it will happen.
The Supreme Court is due to deliver a BBI judgment on notice, the 7-judge bench and their technical teams having retreated to the coast soon after conclusion of the hearings late January. Since then, top political players appear to have moved on to other critical processes leading to the polls. But would BBI still be a factor in the August 9th polls? Should the bench overturn the appellate court verdict on the referendum push, in essence reviving the BBI?
You can conduct a referendum, you can together with the election, and it's still allowed by law, so long as the right process have been followed, and there will be no further challenges in any constitutional court in the future.
Politically, very minimal impact. Perhaps legally, yes, whatever the decision it is, first it will affirm the principles of law with finality. It will state, either confirm the decision on the Court of Appeal or change some of the findings of the Court of Appeal. Ultimately, it will pronounce itself with finality on the various constitutional values.
We are ready for elections, with or without BBI. But when we win, not if, when we win elections next year, certain aspects of the BBI will be implemented.
Yet also an option for the judges is to uphold the appellate court verdict, a decision that would deal the final death knell to the BBI push and extinguish the hope of political players striking coalition agreements on the basis of an expanded executive. A verdict that would mark a major political victory for Deputy President William Ruto, who has been the top BBI critic, and which would also force coalition partners to strike the pre-election 2022 deals on the existing constitutional offices, including the presidency, the second-in-command, cabinet positions and offices of Speaker in both parliamentary houses. A state of affairs, analysts argue, would mark a major turning point in the de-escalation of the presidential ambitions of key State House hopefuls.
You must have realized the big question in all these alliances. For example, when Mudavadi joined UDA, you remember Central Kenya was feeling uneasy because they thought Mudavadi was now coming to take over the deputy president, and then the question was, where do they go? As who are in One Kenya Alliance, and we have been, to some extent, been told, can you join Azimio? The question we're asking ourselves is, if we were to join Azimio today, what would be there for us?
Constitutional amendments must have timelines, strict timelines, so that you don't inconvenience the country. We can't hold the country at ransom because of BBI, and therefore, I'm not too worried about their determination. But the important questions of law, which we need to address.
Politicians will pick it as a point. If BBI is allowed, and that bill is allowed, and the decision at the Court of Appeal is reversed, it's possible that those in politics will want to prove that they were right, and they need to be given an opportunity, perhaps in the next election, being in office, so that they can then implement what has been approved as the bill and the constitutional amendment process.
Whether it is implementable right now or not is okay. That bill was a bill for inclusivity of Kenyans so that nobody feels disfranchised. It was a bill that was going to bring peace among communities. It's a bill that was going to see that corruption is done. So if it is passed, or if we have a reprieve from the Supreme Court, that would be very good.
Some of the key issues for determination at the Apex Court include whether a sitting president can initiate a popular constitutional amendment drive, and whether Kenya's 2010 constitution falls under what has come to be famously dubbed the basic structure doctrine, a finding upon which the High Court and the appellate judges blocked some key suggested changes to the Supreme Law by the BBI bill. And with the clock ticking fast to August 9th, no doubt the Apex Court remains on the spotlight as the pre-election realignments continue. Murimi Mwangi.
Right, so away from that, and anyone earning more than 100,000 shillings